Jennifer, if you have thoughts. Now I wanted to turn, I'm very excited to introduce our guest speaker. Our keynote speaker today is Mr. Greg Gorder from the company Intellectual Ventures. Mr. Gorder's been a long time leading lawyer in the US. He spent a number of years as kind of a top corporate counsel where he was working with startup companies and leading them from inception through some kind of financing, many of them resulting in an IPO or large amounts of private equity into a number of companies that are still going today. At some point he made the leap out of the law firm environment into starting up this new exciting venture called Intellectual Ventures. And from the first day I heard about this company, I thought it was an exciting new idea and had the potential of doing really great things. And they operate on a number of fronts. But the way that I see it most importantly in kind of what you might think of as the patent business world or the patent ecosphere is that Intellectual Ventures is really creating a market for patents in a way that before they jumped into this, it really wasn't there to the degree that it is today, in that we have lots of innovative companies that have innovative products and universities that come out with innovative ideas. They get patent protection, but with those patents, they might not actually be great business leaders, and they're certainly not great at enforcing their rights. And for years and years, we've had these theories of division of labor, but we haven't brought that into the patent world, and instead kind of expected that the same entity that could come up with great ideas could also turn those ideas into a profitable business and enforce those ideas in courts. Intellectual Ventures has in many ways, in many instances, stepped in as a middleman. Now, Intellectual Ventures is something of a flashpoint. In that, and especially if you're a company that previously didn't need to respect patents held by other companies, and instead could just say, well, sue me, Intellectual Ventures steps in and says, well, we'd rather not sue you, but we have the wherewithal to do so if we need to, and so that has changed the dynamic, and lots of people complain, and legislators create laws to some extent, particularly addressing intellectual ventures, and so it's an exciting point. Greg Gorder, so in a sense I mentioned this, he's the co-founder of Intellectual Ventures, along with a small cohort of really creative thinkers. He's played a number of roles at Intellectual Ventures, including being their general counsel, CTO, and I think COO, whatever those letters mean.
I got to clean the toilets too.
Cleans the toilets and build the buildings. I'm just very excited. I think that Greg, after talking with him, he's agreed he's going to have some presentation. But also leave sufficient time for a question and answer session, and he's open to talking about lots of issues. So let's welcome Mr. Greg Gorder.
Good morning, good afternoon, almost. Thank you, Dennis, for both the introduction and for inviting me to come talk to you today. I'm going to talk a little bit today about invention and what we think, looking and thinking about invention for a number of years, how it happens, how we value it, how we discuss, we'll be able to discuss some of the issues involved in dispute resolution, which is the point of the conference here, but also I think some of the limitations that we think that may exist in looking at dispute resolution as being the primary source of value discovery for intellectual property. And then, as we said, there'll be some time, quite a bit of time probably, for Q&A depending on how fast I talk. Incremental is Invention is kind of incremental, as you see here, kind of running through a bunch of different iterations of the keyboard. We tend to think of, particularly, perhaps not so much people in this room, but a lot of politicians, a lot of the general public, and frankly, sometimes a lot of the courts tend to think of invention as kind of a light bulb moment. You know, like, aha, there it is, that's the invention. The fact is that the vast majority of inventions are actually built on previous inventions, adding incremental value and changing the products and services that we use over time. The first successful typewriter, which is kind of the basis for the keyboard, was built in 1868 and had a keyboard that was circular, not like this one, but like the first picture that was up there. And during the past 140 years, there's been incremental change. If you come to IV, we actually have in our lobby row upon row of actual typewriters. And the incremental changes that were involved in typewriting. And those incremental changes are actually key to providing a lot of value. Another example of incremental change is the car dashboard. It's kind of the user interface for cars. It's changed a lot over the last 70 years, adding a whole bunch of inventions. And so today's dashboard looks nothing like the dashboards of the 1940s. You'll have, in your car today, usually a GPS system, if you bought a car recently. If you're a student, maybe you haven't. Satellite radio, heated seats, intermittent wiper blades, backup cameras, cruise control, iPhone plugs, all kinds of things that didn't exist for your parents' cars, your grandparents' cars, and so forth. And while we see the incremental improvements on the dashboard, there have been thousands of additional incremental inventions involved in transportation. So if you think about it, whether you think about tools, transportation, or toys, there's been a lot of incremental change. The cell phone is one of those that's like, is it a toy, is it a tool? One of the things it's not yet is transportation, but hang on, maybe we'll get there. The cell phone was first built by Motorola in 1973, and is basically that huge brick that we saw in the first place. When I was early practicing law, I represented Cellular One, which was Macaw Cellular, and had one of those bricks. It was quite expensive to operate, but the clients were paying, so whatever, 40 years later, we've pretty much got incredibly advanced cell phones, smartphones in our pockets, or if I'm getting boring, in your hand. What we benefit from is this kind of incremental invention that really brings a lot of difference. And so if you think about invention, what it's doing is it's solving problems, and it's solving problems that have value, that make differences. If you think about the advances for the last 70 years of productivity or quality of life, they're almost all based in invention. So it's very important that we kind of keep thinking about what makes invention work for us. Tens of thousands of incremental inventions over a short period of time converging into a device we've all got in our pockets, and even your kids can probably afford. Another factor about incremental invention is that it's harder to actually see. You get a lot of changes in the way that technology works. Software programs. Typical software program may be hundreds of thousands or even millions of lines of code. Some of those lines of code are not inventions, but there are some lines of code that are actually quite inventive. They actually are probably patentable. They meet the standards for being novel, non-obvious, and useful. But there's just a handful of people that know about them. They're very important. They make your cell phone work, they make your computer work, and so forth. But it's not easy to see. And inventions that are hard to see are hard for people to understand. They're even harder to value and for courts in the dispute resolution context to decide what to do in a dispute. Another part of invention is that incremental invention supports the convergence that we all benefit from. And that's another area where it's very hard to say, well, let's have a dispute. Let's resolve that dispute over which invention, is it infringed, is it valid, is it enforceable, and how much is it worth? Well, when you bring incremental inventions, hard to see inventions, convergent inventions all together, we can all agree it creates a huge amount of value and it really makes a difference in the world, but it's hard to resolve in a dispute kind of a context. Another part of invention that's significant is that it's not happening just in the U.S. Contrary to popular belief, Silicon Valley is not the only place that inventions happen. They happen all over the world. Even if you're looking just at the inventions that are in your cell phone, they're happening worldwide. And that's an important part of invention. Humans by nature are inventive. It kind of distinguishes us from the rest of the animals. But it's not just the humans in the United States. It's not just the humans in the first world. It's the humans all over the world that can be inventive. Inventions also don't just come from large technology manufacturing companies. Inventions come from individuals. They come from individuals. In fact, all inventions come from individuals, even those that are employed by large manufacturing companies. They come from individuals that are employed by research institutions, universities, individuals that are employed by companies that actually don't do a darn thing associated with the invention. A lot of inventions come out of individuals who are thinking about something other than their day job while they're at work. Boeing is a prime example. There's a lot of inventions that have happened at Boeing that have nothing to do with making airplanes, right? And if you look here, there's some examples. About half of the inventions in the world today are actually coming from research institutions, universities, small to medium-sized enterprises, and individuals. And so, if you think that inventions are really all about big companies, the data does not support that. One of the things that's really important when you're thinking about dispute resolution is like, well, how do the inventions exist in the world? We tend to think, oh my gosh, yes, the big invention holders. This is a distribution of the patent portfolios in the world of the kinds of technology that intellectual ventures invest in. So if you think about the kinds of things that we do, it tends to be more associated with bits and bytes, wireless networking, telecommunications, and so forth. It's the kind of stuff we tend to think of as high tech. We also do some material science and some biotech stuff, but it's a lot less of the area that we do. In this area that we're involved in, you can see there's a relatively small number of large patent portfolios, okay? And there's a huge number, 2,500 patent portfolios out there that have inventions in the area that what we think of as high tech. Of those 2,500 owners, there's nearly 850,000 patents, but fewer than 40 portfolios hold more than 5,000 at a time. At the end of the visible graph here, over in this area, that 350th size of patent portfolio is actually only holds about 250 patents. And when you get down to the end there at the part of the page you can't actually see, there are 800 patent holders that have fewer than 5 patents each. Now, if you're a company and you're actually trying not to free ride on other people's inventions, this presents a huge problem for you. If you're someone who is trying to say, let's make the incentive system for inventions work for all of us to encourage this thing that we agree has brought us a lot of increases in productivity and quality of life, we need to make that incentive system work, not only for the people who are here at the big end of the scale, but for people who are all the way throughout the scale. And for most technology manufacturing companies, that is a challenge that they've found kind of beyond them so far to date. Most technology companies have not gone out of their way to try to find a solution to their inventions. One of the reasons that it's hard for them to do so, these three reasons kind of contribute to the difficulty that they face. There's a race to invent. So it doesn't matter if Boeing, I'm going to keep using you as an example here, sorry.
That's fine.
If Boeing engineer invents something, if there are 10 other people throughout the world that have beat them to it. And in the first to file world, Boeing may be able to file their invention first, but they may not. And in fact, the way that it works, because the rights for an invention are granted to the first one to file, or the first one to invent, depending on whether you're in this decade or other decades, the patent office takes a number of years, generally 3 to 4 years, to issue the patent, which declares who won the race. Now, if you file for a patent, you got a good patent lawyer, chances are high, probably 85%, that you'll get a patent. But unless you're the first one to the finish line, you're not going to get the patent that says you got the fundamental invention. You're going to get a different patent, and it's going to say you have an incremental invention. And if you went out and you said, let's launch a product based on my fundamental invention, your product may actually be in the marketplace before the patent office declares whether or not you actually won the big race or you won that kind of secondary race. If you did, as a manufacturing company, go out and try to find, well, let's find all the patents that we need to build a product. Let's just assume it's a simple product, and you just need to find the inventions that may or may not have beat that one engineer doing one patent in your business. If you went out and looked for them, and you found a bunch of those patents, and you didn't have rights for those patents, and you continue to manufacture your product, you've got the potential for treble damages for willful infringement. So you can see that technology manufacturing companies, even if they only had one invention in their product, have an uphill battle. But most technology manufacturing companies don't have just one invention in their product. They have thousands. They have thousands and thousands of inventions. And so what do they have? They've got an invention gap. They've got more rights. They've got more inventions in their products than they have rights to. And for us as a society, that can be a problem. Why is it a problem? Well, because the patent system is there, and all of you guys are involved in the patent system, or you probably wouldn't be here today. It's there to provide incentives to inventors. It's not incentives to manufacturers, it's incentives to inventors. And if we have too many manufacturers that are free riding on that incentive system, then that incentive isn't going to work. We look at the invention gap problem a lot in intellectual ventures. It's an important part of our business, of understanding how inventions work. So we've got an example here. It's a real company. It's Blackberry. Well, it's currently a company. Maybe in the future. So Blackberry actually is a fairly substantial inventor. And Blackberry's been involved in the handset business for a while. They've got over 2,400 patents, okay? That's a large patent portfolio. That's actually a pretty good size. But you know, here's the thing. Even if you look at their top 5 competitors, which kind of covers most of the cell phone market, you see that Blackberry barely has 10, just a little bit over 10% of the patent portfolios just between it and its competitors. And then if we look, what we've done with the software that we've been developing in intellectual ventures is looking and trying to say, well, what does invention gap look like? So we look at Blackberry, we look at its competitors, we look at where they overlap. Okay, so we're trying to say what is like what they did. Now, it's a good proxy. You might be able to come up with a better proxy, but it's a pretty good proxy. And the rest of the world owns over 300,000 patents in the same types of technologies as BlackBerry and its top 5 competitors. And I'm not counting Apple's computers inventions here when we're counting Apple as one of BlackBerry's competitors. We're counting Apple's smartphone patents. So we're looking at an area that's very relevant. So what's a company like BlackBerry going to do? Well, let's go to dispute resolution, right? Let's use the courts to resolve the dispute to say, for BlackBerry, which of those 350,000 patents BlackBerry should take a license to. Because nobody says all of them are infringed, valid, and enforceable. But some of them are. BlackBerry doesn't have all the patents that it needs for its product. And I think everybody pretty much agrees that there are at least tens of thousands, if not hundreds of thousands, of patented inventions in a smartphone. BlackBerry only has 2,400, so it can't have all of the inventions that it needs. And the court system, is there to resolve those disputes, but it's kind of not really very good. The court system, patent cases are slow and inefficient. The courts are generally willing to hear cases with only 10 or fewer patents. There may be some exceptions out there, but I think that's a general rule that's safe to say. They take an average of 2.5 years to resolve each case, and so let's take BlackBerry through the system. BlackBerry, its competitors, and the rest of the world hold more than 350,000 patents. So let's make a couple of conservative assumptions here and decide how well the courts are going to do at resolving BlackBerry's invention gap. Let's assume that only 1% of the 350,000 assets actually read on BlackBerry's technologies. Let's assume further that each case, the court would look at the full 10 patents, not say 5, not say 4, not say 3, but full 10. If each case took 2 years, not 2.5, not 3, not 4, not 5, it would take 700 case years for the court system to resolve even a tiny proportion of BlackBerry's invention gap. Now, as a patent investor, I'm not really happy with that because patents only last for 20 years, and 700 is a lot longer than 20. So I'm looking at this and saying, as someone who puts a lot of money into patents, relying on the court system to resolve the invention gap, to be able to decide who needs the license to which patents, is not very useful. And it's not just a problem for Blackberry, it's a larger economic problem because it hurts inventors as well as manufacturing companies. The system intends to be an incentive for inventors, but there's a problem if we don't have this efficiency to allocate compensation for the inventions that do end up in products and services. We disincentivize invention. Right now, there are some inventors, perhaps thousands and thousands of them, that have legitimate claims on technology. They're being used by successful and profitable companies to make billions and billions of dollars of profits. They're actually successful. They've got enough money, they have enough connections, they can have enough patience, and their patent has enough life left on it, so they can go to the courts and say, resolve my dispute. Decide whether or not my patent is valid, infringed, and enforceable. But there are thousands and thousands and thousands of inventors, of patent holders, of people who have the legitimately granted invention rights that our system uses to give an incentive to inventors, that they're never going to get compensated for those inventions. And if you look at this as saying, well, does our dispute resolution system work? I think you have to answer that the answer is no, it doesn't. Not very well. So what do we think? I think there's a better way. I think that, I was, before I went to law school, an economics major, and if any of you ask me patent law questions, I probably won't be able to answer because I wasn't a patent lawyer. I'm more of a business guy. I'm more of an economist. And one of the ways that I think that actually works pretty well is to build an invention economy. So one of the things that's very helpful at deciding, well, how much is this invention contributing? How many people want to use this invention is actually to bring in those dreaded NPEs and put them to work. Why does that work? Well, because that makes a system in which there are buyers and sellers. You make invention rights transferable, which they're supposed to be. You bring in investors to the space, and you provide a virtuous cycle between sources of invention and users of invention. Manufacturers are users of invention. Some of those inventions come from their own system, but a lot of those inventions don't. And most manufacturers, what they really want, and what we're finding in talking with manufacturing companies that are looking to satisfy their invention obligations and to not free ride, is that they're interested in actually gaining access to the invention rights that they need to manufacture their products. But that access has to be fair, efficient, scalable, and transparent. To the extent that we create a system that it's all like, well, depends on who you know, depends on how much money you have, and depends on how long you can wait, then that doesn't work very well. So what does this invention economy do? I think I just went through very efficient, predictable, and I think that if you measure an invention economy, an economy in which you've got patents that are freely transferable, you've got a market maker like intellectual ventures, but you know what? It can be other people too that are buying and selling invention rights that don't manufacture, and that's like, oh, bad, NPE, patent troll, don't manufacture. Well, I think if you think about it a little bit, I don't manufacture products, so do I want to kick people out? Do I want to have them stop using my invention? Hell no. I want them all to use my invention, but I want them to pay a fair price for it. So if you think about this from a consumer standpoint or from an antitrust standpoint, it's actually a lot better to have a marketplace in which a lot of invention rights are in fact held by NPEs who only make money if they license those companies that manufacture products using those inventions, than it is if you put Apple and Samsung, for example, trying to kick each other out of the market so they can have monopoly profits. Intellectual Ventures has been doing this. We've put more than $2.3 billion to work in the invention economy. A lot of that has gone to small and individual inventors, universities and research institutions, but a lot of that money has also gone to big companies. Because big companies, too, invent products, invent solutions, invent technologies that they can't use, or they can't use fully, or they've got a bunch of invention rights, so they've got patents in their chief IP counsel's office, and they just sit in a drawer. They don't actually do anything. And so, what we're finding is that the dispute resolution system that I think can actually work better for society is one that we've been a proponent of. So that's all I have to say. So questions? Yeah.
It seems to me, I actually agree with most of what you said.
Oh, well, I can go home.
One of the problems in invention economy is evaluation, right?
Right.
Not necessarily the resolution of a dispute, but how do you know what a patent covers? How do you know what it's worth? You actually have to hire patent attorneys at a higher rate to value that asset. How do you do that in your invention economy?
Well, you know, that's the interesting thing about an invention economy is that when you have willing buyers and willing sellers, then you have the potential of creating a market pricing. So, you know, intellectual ventures isn't the only people out there buying inventions, although from time to time, you know, folks at Ocean Tomo thought so because we bought a lot of the patents out of their auctions. And I think that the key component to that, though, is that there are willing buyers and sellers, and so we're going to price the inventions at a price that we think we can make money. Because we're investors, so if we can't buy low and sell high, our business doesn't really work. The way to do that is to actually have a functioning economy, invention economy, in which there are multiple buyers and sellers. Yeah, I think eventually intellectual ventures will have competition. We certainly do at this point. Technology manufacturing companies, you know, they actually buy a lot of patents directly, and there are a lot of folks like RPX and Acacia and AST and so forth that are also out there buying patents.
It seems to me that what history's taught us is it's much easier for a company to look at an invention, tweak it a little bit to argue the design around it, and then say sue. And so
Look at invention,
and
design around it, and then say so.
then you sue. Now, if it's Apple saying Samsung suing, well then
Yeah.
the fight is on.
Yeah.
But when it's an NPE, that happens a lot less. And isn't there an economic or financial incentive for bigger companies to basically say, I'm going to take the risk, because at worst, I'm going to have to pay whatever reasonable royalty is.
Yeah.
And why should I, maybe, and if I do even the smallest amount of it, looking at attempting to design around, I can argue it wasn't willful infringement and get my gold-plated
Yeah.
patent attorney opinion to say that. And isn't the economics such that, you know, it's just, as much as I agree with your invention economy, the reality is it's a predatory economy, and I don't see people cooperating as much as I see people just deciding that we're going to take the risk.
So, if I understand what you're saying, I think we're in violent agreement. You know, I think that the system that we have right now, and you know, post-grant review was a good example. Good in theory, but you know, we actually kind of screwed it up a little bit in practice. And so, what happens is that we've got a system that for companies that make a large, obscene amount of profit, it actually, many of them are inclined to free ride because free riding is cheaper. When my co-founder Peter Detkin came on board, he came to us from Intel, where he was the guy in charge of patents and antitrust and litigation and so forth. And he said, well, there's this fight or flight number, fight or settle number, basically. You know, if you can basically hire lawyers and just delay, free ride for a longer and longer period of time, that puts a cap on the amount, you know, it's not a cap on the amount of profit you're getting from the invention, it's a cap on the amount you're willing to pay. And that's a challenge. It's certainly a challenge for undercapitalized inventors that, you know, may have rights that are worth a lot of money because, you know, companies like Intel or Apple or Samsung, yeah, they can pay lawyers a lot of money for a long period of time to just fight. And so that's part of my argument, actually, that the court system is inadequate to actually address the invention gap. And intellectual ventures, we do sue people. We have to. If you allow too many free riders in an economy, your economy crumbles. And so you can't allow. I mean, the companies that have paid us a lot of money, there's a lot of companies that paid us a lot of money. They're not happy if their competitors are free riding. They're like, wait a minute, my costs are higher. You know, their costs should at least be equal or you know, same as mine. I think another problem with the court system is this idea that at the end of a very long, very contentious, very risky dispute resolution mechanism, what does the court do? It charges the floor, not the ceiling. So reasonable royalty is supposed to be a floor. So the guy who actually pays a reasonable royalty on a voluntary basis to say, look,
I want to do the right thing. I don't want a free ride. I want to encourage inventors. I want to use inventions. I want to build very complex products that make me a lot of money. Those guys are going to pay the same amount as the guy who says, I'm not going to pay anyone. I'm going to free ride everybody else's inventions, and I'm going to make as much money as I can and neener, you know, to use a complex legal term. Yeah.
So, in response to the first question, you mentioned competition in this new market for patents, and you mentioned Acacia and RPX kind of in the same breath, and I'm curious.
Not because I think they're the same.
No, they would think of themselves quite differently, and so RPX, in fact, you know, they're on the lecture circuit, they speak a lot, and they often make a point of differentiating themselves with intellectual ventures.
Sure.
They're portraying
They were
themselves
former
as,
executives of ours before they started out.
I know everybody knows it, no, understood. And they portray themselves as, you know, the good aggregator, right? How do you differentiate yourself and your business model from RPX? Because it seems like you two are moving as the two big players in the market.
It's a different strategy. So if you think about RPX is kind of a co-op or a club whose members put in money, and then the club goes out and, you know, purportedly buys them out of their problems. It's kind of a collective kind of a thing. And I think that it's fine. I think RPX encourages tech manufacturing companies to think of the patent holders as the problem rather than their invention gap as the problem. And we have many of the same customers. And IV, Intellectual Ventures, it's actually, I think, a better solution if you're trying to resolve your entire invention gap, because Intellectual Ventures is out there investing in inventions every day. You know, and so we're buying patents, not because they're a problem for a particular company. We tend not to buy patents out of litigation because by then they're really expensive, and as an investor I want to buy low, sell high. As a kind of a insurance collective club, RPX is more willing to buy high and then charge its club members, you know, for the higher price that they incurred because they waited too long. And so it's, you know, it's kind of a different thing. Now, if you're an inventor, which model gives you more incentives? The RPX model or the Intellectual Ventures model? I think the Intellectual Ventures model. In part because Intellectual Ventures is investing in invention across, you know, over 250 different technology categories. We're investing in inventions on the basis not of who you've sued already, but rather what we think your invention is going to provide value to the marketplace. And it can be hundreds of companies that it provides value to. So, two different models. I think they're compatible. There's nothing wrong with RPX. I just think we kind of look at the world a little differently. Yeah.
I would like to address the invention gap a little bit. You talk about the patents that are owned by the manufacturer.
Right.
But what you don't talk about are those that are owned by the sub-assemblies that they purchase.
Yeah.
They're covered under the UCC. And so you have this indemnification. And so I think if you actually look at the gap, it's a lot narrower than they're sort of, you know, suggesting.
So you're saying that the sub-assembly manufacturers have all the rights to the invention?
Well, they have their rights.
No, they have their rights.
Right.
They have their rights. They don't have all the rights. So even the sub-assembly, many times, will be using inventions that they don't have rights to. Now, if you're saying that make, use, or sell doesn't mean make, use, or sell, it only means make, or it only means sell, or it only means use, then I think your argument may have some legitimacy. But what you're saying is, if I buy a sub-assembly from someone who's given me a patent indemnity, I'm home free.
No.
I would say, no, that's an insurance policy you bought. And your insurance policy is as good as the financial well-being of your insurer. For many companies,
Right.
the sub-assembly manufacturers, the vendors that Boeing or Amazon or Apple
Blackberry.
buys from, they're some of the leanest run companies in the world. They're making very narrow profit margins. And you're saying only the skinniest, cheapest most underfunded companies in the world are the ones responsible for patent infringement, I would say that that's not necessarily what the model or the statute entails.
Well, that's not what I'm suggesting. What I'm suggesting
Oh, darn, that was an easy one.
what I'm actually suggesting is your first chart.
Yeah,
Okay, if you really want to have a point on what is that other 93%, how much of that is the competitors, granted
Right.
6%, whatever, and then you look at
So
that 93%
right,
in that same technology field,
right.
okay, how many of that is probably the sub-assemblies? And
So-
I know you can't dig down that deep.
No, we can't. We can't. We're actually, I've invested a lot and actually patented some software that we've developed that actually helps companies to try to evaluate their invention gap. So, to the extent that a company has, for example, cross licenses with its competitors, to the extent that a company has gotten, reasonable assurances of some sort from its vendors and so forth, we can actually help companies to make decisions about what parts of their invention gap they're actually, what parts, because they represent different kinds of risk. Your competitor, yeah, might represent a risk, but you may have that mutually assured destruction thing going even if you don't have a cross license. Your vendors, yeah, I mean, you may not actually have a patent license with them, but you have enough economic strength to say, look, their inventions I don't care about. But then, what we help them to look at is where's the rest.
Well, you do care about
You do
your
care.
vendors'
You do care, but
inventions.
You may not need an invention economy like intellectual ventures provides to provide you with a reasonable amount of insurance that the danger that you're going to be upset or face some kind of a dispute from those inventions is less than the inventions in what we call the long tail, that long bit of inventions that are just out there in the world, and they don't have anything to do with you or your competitors or your vendors. So we try to actually help companies distinguish, where those risks are. Yeah.
You mentioned free writing several times, and that kind of implies knowledge of that the invention is owned by someone else. So, for example,
Not necessarily. I don't intend that. I mean,
but so looking at the chart, BlackBerry may own like 2,500 patents, and the world may own a lot more that are relevant to them, but they may not be aware that those other companies' patents exist, and they may have independently invented the technology. And this is true, I think, of many companies where they may, especially in the high-tech sector, where they come to the same solution, they just involve patenting it. So the issue is then how do you encourage them to participate in the market, to go to the market and say, hey, what covers our product, and how can we buy a license, and how do you encourage that cooperation rather than that the default is to have companies defect and say, hey, if nobody participates in the market, then IB has to police the market, and that's very expensive, and they won't be able to, and we're all free.
no, and the point you make is a good one. There are companies that do patent clearance before they launch products, and there are companies that really actively do a hear no evil, see no evil, speak no evil kind of a thing. Oh, they may speak lobbyist, but they don't speak evil. And I think that one of the key components to controlling free ride, to creating a viable invention economy, is to have the court. It actually is to have the court system play a part, and the part that the court system plays is to help police the free rider component. I think that if a voluntary invention economy is going to exist, the price should be higher for free riders, who at the end of the dispute go, okay, charge me the same price as the guy who actually paid 10 years ago. I mean, really? That's not going to work very well. So I think courts have to be involved, and I think that they have to differentiate. And there's been a sense in a lot of the writing and a lot of the court decisions. If you look at Judge Posner's decisions, he's actively against patents. He seems to be. Some of the things, I don't know him personally, so I can't say that that's the case. But and I think that a lot of the academic literature that has come out is kind of positing this. Well, invention rights are just a drag on the economy. That real innovation is manufacturing. That anything that isn't manufacturing doesn't really count. It's kind of like saying, real songwriting is if you perform. And it's like, well, no, songwriting is different than performance, and songwriting is good and performance is good. We're going to protect each of them. So I think that the things that the court system has said and done under this theory that I think is misguided of a lot of academics that patents are bad. Look, patents that are not actually issued in respect of inventions that are unique and useful and novel, we shouldn't issue them. A complaint about patent complexity is legitimate. I think patents are complex. I read a lot of patents, and half of them I don't understand what the hell they say. But if you think about it, that's endemic to what we're trying to do as, I don't know how many patent prosecutors there are here, but that's endemic to what you're trying to do as a patent prosecutor, is you're taking something that is, by definition, brand new. So it doesn't exist anymore. Now, it may be incremental, so you can look at the things that have existed before when you're filling out your list of prior art and so forth, you can describe them. But you're describing something brand new, and you're entitled to use your own language. You can make up your own language. You can describe it whatever language you want to do, as long as you define the terms you're using. When that happens, of course it's going to be a little bit odd. You're not going to find that today's smartphone is described accurately in a 10 or 15-year-old patent, because they just use different language. So I think we can do better by trying to do a better job of the metes and bounds of patents and making sure that patents that are issuing for good, novel, useful inventions. But that's really hard. And I think that the patent office, Jared, were you actually at the patent office? Yeah, I think the patent office is doing a good job. I think particularly since David Kapos took over as the head of the patent office, it's done an even better job of trying to really only issue patents for good inventions. But it's still hard, and that's where our view is that rather than look at each patent and each patent claim and say, is it valid, enforceable, and infringed? Let's decide in a 2.5-year court case that's going to cost us each $2 million or more. We're saying let's aggregate the patents. Let's invest in the patents. Let's look at this as a scaled problem, and let's deal with it as a scaled problem. Let's put those packages of invention rights together, and let's have manufacturers pay a reasonable, predictable, fair, and efficient price to have access to those invention rights that they need. So that's really what we're doing.
We have a product, like you say, a cellular phone that might be covered by 350,000 patents. Wouldn't it be the case if all of those patent holders actually extracted a royalty from that manufacturer, that it'd be impossible to make a profit on any product, or that the actual value of each patent would be so small that it wouldn't be worth?
So it's a good question, but here's the thing. Look around this building. How many different pieces are there? Probably more than 350,000. Count the bricks. Are you saying that we should, really, the brick guys shouldn't get paid for the bricks because, there's a lot of bricks here, so, what? Now, I think that the right way to do it is to actually put market forces to work. We don't pay the same price for each patent we buy. Absolutely not. I mean, there's an average price. There's a huge amount of variation. We paid over $1 million per patent for some patents we bought. And heck, when we got started, at one point our IT guy bought a patent on the kind of commercial equivalent of eBay for $5,000. There's a large variation in the value of inventions. There's a large variation in how well patents are drafted. There's a variation in how old they are. There's a variation in which geographies they cover. There's a variation in how large is the family. Do they have divisionals, have continuations, and so forth. And then how easy or difficult is that patent to see in practice. So I described, some inventions are very difficult. Almost no one knows about them. And if you have to do a complex reverse engineering project, it changes the value of the patent. Having said that, though, there is an aggregate value. I would say as an economist, the difference in a company's profits for a company that has new technologies versus a company that's in a commodity space where there's a lot of old technologies and none of them are rights protected and there's a huge amount of competition, that difference in the profitability is the value of those inventions. Now, there may be other differences in profitability between different companies. They may have different management systems, they may have different distribution channels, they have different brand value and so forth. So I'm not arguing that invented rights protected inventions are all of the profitable difference between tech companies and commodity companies, but it's a huge part of that. And so what's the right allocation? I'm saying that the courts are not the best place to make that very large, 350,000. Look, some of those 350,000 patents, they're not infringed. They're not valid, they're not enforceable. Some of them aren't even still, alive because no one paid the maintenance fees on them. What we're doing as a market maker, as an investor, is we're looking, we've actually, in the course of the last 10 years, we've looked at over 350,000 patents. We've bought over 80,000. We're actually using, in our licensing programs, only 35,000. So we're quite picky. And we actually make a large differentiation between patents that have value and patents that don't. So, I don't know if that helps. Yeah.
So, do you think the American Invents Act has helped or hurt the U.S. invention economy?
We were involved. Not me personally. I'm not the detailed statutory interpretation guy. We were actually we're quite involved in trying to help come up with a patent reform that didn't gut our patent system. I think there's some things that the American Invents Act has that are good. It's actually not a bad thing to have first to file. There may be some small inventors or some university professors who are like, oh, really, I should have first to invent. But putting us in line with the rest of the world, that's over the course of time, that's probably a good thing. Really, it's better if the world has kind of a consistent patent laws because a lot of the economies in which invention heavy products are sold cover more than just the United States territory. So I think some parts of that are good. I think that some parts of the post-grant review process are not good. I think that they kind of undercut the incentives for inventors. As an investor invention, look, I'm investing in a life-limited asset. It's got 20 years. No matter what I say or do, it's got 20 years. And if we're allowing post-grant review that really is a delaying tactic, and I think is, how many defense lawyers are there in the room here? None. Wow. Certainly a lot of the defense lawyers that I've talked to are saying, we use post-grant review as part of our active defense project. We ended up, one of our investors, who was a customer, actually sued us, Xilinx, and Xilinx went out and just re-examined the shit out of our patents. Even patents that weren't even litigation. They were just like, hey, throw more re-exams at IV because that will, I don't know, annoy them, cost them money. So I think there's a lot of companies that are, are using some parts of the American Invents Act as, more free rider strategies. So that doesn't really help.
How do you approach someone that you think may be violating a patent, but you want to approach them without triggering a declaratory judgment?
Yeah, there's a well-known dance. I'm not the one who dances that dance, but there is a way to do that. Often too, you can do it by agreeing. Look, we're going to have a conversation about a mutually beneficial relationship, and you're not going to go file a DJ. I'm actually talking with companies right now. With my chief of staff, we travel around the United States, and we're talking with several companies about taking a license to the inventions I haven't bought yet. Okay, because I'm talking to companies that actually understand they have a problem. I'm not the problem. The NPEs are not the problem. Patent trolls aren't the problem. Their invention gap is their problem. And their business has an invention gap that's systemic to their business. No matter what they do, they will have more inventions in their products than they have rights to. So they're working with me to actually have a relationship, a partnership with Intellectual Ventures that incentivizes intellectual ventures to go out and buy good inventions that are protected by valid legal rights, that are priced fairly, and make those invention rights available to that company on a non-exclusive basis so that they don't free ride as much as they might otherwise. So, certainly I can have that kind of a conversation with a customer because I'm talking about inventions I don't even own. So how are you going to DJ me that on that?
Go ahead, yeah.
On the other hand, there's a lot of patents we do own that are not licensed yet by companies that should take a license to them. So, we have this, funny business model that, I'd actually like to just have relationships with companies that say, look, we're going to invest in some great inventions. You can have access to those inventions. You pay us some money. It's a win-win type of relationship. But because we're new, we're disruptive, we're different, there's a lot of companies that say, conventional wisdom is that I should just free ride as long as possible. I have this guy, he's my patent lawyer. You know what his job is? It's to stand at the door and go, talk to the hand. Not infringed, not enforceable, non-valid, and by the way, good luck proving the accuracy. And just to do that as long as possible. That is the conventional wisdom of how patents are not licensed. So we're changing that, and it's a little disruptive and it kind of pisses people off. And some people hire lobbyists to try to pass laws to go after us. But it's a good thing. Oh, whoa. Okay.
I think we're going to, so let me just interject. I think we're going to go till 10 after.
Okay.
And then we'll
We got
stop.
4 minutes. I'll talk fast. You in the back.
So doesn't that, I kind of agree with you, the model you set up, doesn't that kind of lead to almost a negative invention gap at some point once you have this, the number and breadth of the patents that you own to where you need to get a license, you need to get a license in some of them, but because you have all these other ones, I can't individually analyze them and figure out exactly which ones I need a license to. So I'm actually paying for more patents and licenses than I may need to bring.
Well, there's two. I'm going to interject and we'll try to get one more question in. There's two things. One is that I think some companies during some parts of their existence actually have an invention surplus. Maybe it's early stage companies, maybe it's early companies that invest heavily in R&D. And those companies should actually get compensated for that surplus. If what you're saying is that by aggregating patents into portfolios, some companies may technically be paying for a patent that they don't infringe, or that is invalid or is not enforceable. My point is that you actually you make a more efficient economy by doing kind of packaged products that are broader perhaps than you need. I suspect.
Because that happens now.
I was just going to say, I suspect you have an operating system, either in your pocket or on your desk or in your briefcase. And I would wager that you have not used all of the lines of code in that operating system. But you gain a great deal of value from having them all there when you need them. So, having a package of invention rights that gives a company access to the invention rights they need. Look, tailor it as tightly as you want to. But if you only want to buy the lines of code that you're going to really actually use, you're going to move them back into the 70s. And you're going to have to pay for custom development. And so it's a way of looking at this and say, look, packaged software, just like packaged inventions, has value in the packaging.
I would like your comments on a situation where most NPs, let me rephrase that. Many NPs have a litigation or an assertion strategy where they go after the end user as opposed to the manufacturer of the technology. And I presume that the purpose for that is because you can get more licensing revenue by all of the end users as opposed to the manufacturer who will require a license that then passes down to its customers, i.e. the end users. So, two questions. One, could you comment on, is there a certain rationale that you see in that litigation or assertion strategy? And second, how do you think that affects incentivizing invention, which was kind of the premise that you began with?
So I can't speak for anybody else.
But yourself.
I don't know what they think about, what they do. And there are some people who I think my partner Peter Detkin would probably count as trolls. I mean, they're just trying to go after the weak and lame in the halt. From my standpoint, I look at it as an economic matter. There's two components to this. The losses make users sell. So ideally, all people who, or companies who make, use, or sell, product containing or using that invention would have to have a license. Now, the courts have doctrines of implied license and exhaustion. They try to say if you license somebody earlier in the stream of commerce, everybody later in the stream of commerce is licensed. Sometimes the guy earlier in the stream of commerce is the guy who's making the least amount of money. I mean, that's the whole idea that you have to sue the manufacturer. Who the hell is that? But the manufacturer ignores the fact that the manufacturer may not actually be the one who's gaining the most economically from using the invention. So when I look at it, we launched a lot of lawsuits against certain banks in the banking industry. Those banks are using, we think, patented technology to make a great deal of money in processing payment transactions. That's where a lot of banks make most of their money these days. Most of that is due to a lot of patented technology that the banks don't have a license to. The manufacturers of this technology don't have a license to either, but those guys aren't making nearly as much money using those, selling those payment processing systems as the payment processors are. So, as someone who's looking to develop a return for investors for making a risky investment in an invention, I'm going to look to say where in this landscape are the profits for those inventions most voluminous, and try to go and have a fair portion of that. Thank you all very much.